12 federal judges just delivered devastating blows to Donald Trump in a single week. And these aren't liberal activists appointed by Barack Obama or Joe Biden. Multiple judges nominated by Republican presidents, including 2 appointed by Trump himself during his first term, have now ruled that his executive actions are unconstitutional, illegal, and in some cases, downright dangerous to American democracy. When a Reagan appointee with 40 years on the bench looks into a camera and declares that he has never seen anything so blatantly unconstitutional in his entire career, you know something seismic has just occurred. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what exactly triggered this unprecedented judicial rebellion? A Bloomberg analysis found that as of May, courts had entered more than 200 orders stopping the administration's actions across 128 separate cases. That's not a typo. 200 court orders blocking a sitting president. And here's the part that demolishes the White House narrative entirely. Nearly 24% of the judges issuing these rulings against Trump were appointed by Republican presidents. This isn't partisan overreach. This is the American judiciary doing its constitutional duty. And believe me, when judges appointed by Ronald Reagan, George W. Bush, and even Trump himself start ruling against this administration, you know the legal foundation beneath these executive orders has completely crumbled. It's honestly hard to believe we're watching the judicial branch unite against a president's agenda at a scale we haven't witnessed in modern American history. Here's the full picture of what's been unfolding. Tensions between the executive branch and the federal judiciary have been building since January 20th, fueled by a flood of executive orders that legal scholars immediately flagged as constitutionally problematic. But everything escalated dramatically in the final weeks of 2025 when a Washington Post analysis revealed something stunning. The Trump administration had defied court orders in roughly 1/3 of all cases where judges ruled against them. 1/3. Legal experts describe this pattern of noncompliance as unprecedented for any presidential administration in American history. The trigger for this latest wave of judicial pushback came on multiple fronts. First, Judge John Coffenor in Seattle blocked Trump's birthright citizenship order, calling it from the bench, and I'm quoting directly here, blatantly unconstitutional. Then Judge Amit Mehta in Washington ruled that the administration violated the Fifth Amendment by targeting energy grants specifically to punish states that voted against Trump in 2024. And a cascade of additional rulings followed, blocking everything from refugee bans to federal funding freezes to attacks on law firms representing clients the president doesn't like. Smash that like button if this is making sense so far. Here's where it really gets serious. When federal judges across the country reviewed the evidence in these cases, they recognized immediately that constitutional lines had been crossed. And let's be honest for a moment. Federal judges don't issue temporary restraining orders and preliminary injunctions over policy disagreements or partisan concerns. They issue them when they believe fundamental constitutional principles are under direct assault. Here's what multiple sources report happened next. On January 23, 2025, just 3 days after Trump took office, Judge John Coffenor heard arguments in a Seattle federal courtroom. The hearing lasted only 25 minutes. Sources who were present say the Reagan-appointed judge appeared visibly frustrated with the government's arguments. When the Justice Department attorney finished his presentation, Coffenor didn't hesitate. "I've been on the bench for over 4 decades, he said, his voice carrying an unusual edge. I can't remember another case where the question presented is as clear as this one." He paused, letting the weight of his words settle over the courtroom. "This is a blatantly unconstitutional order." The courtroom fell silent. Reporters leaned forward. Washington State Attorney General Nick Brown, who had filed the lawsuit, later told the press that hearing a Reagan appointee use such forceful language set the tone for the seriousness of what the country was witnessing. But Coffenor wasn't finished. In a subsequent hearing on February 6th, he went even further, delivering remarks that sent shockwaves through the legal community. "It has become ever more apparent that to our president, the rule of law is but an impediment to his policy goals," Coffenor declared from the bench. "In this courtroom and under my watch, the rule of law is a bright beacon which I intend to follow." That's when it became clear this isn't just another political scandal. This is the federal judiciary drawing a line in the sand against executive overreach. When a judge appointed by Ronald Reagan, serving on the bench since 1981, publicly accuses a Republican president of treating the Constitution as an obstacle to be circumvented, we've entered genuinely unprecedented territory. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. Judge Kavanagh's ruling wasn't isolated. Within 48 hours, a second federal judge, Deborah Boardman in Maryland, issued her own preliminary injunction blocking the same birthright citizenship order. And across the country, the pattern repeated. Judge Amir Ali ordered the administration to release frozen foreign aid funds. Judge Amy Berman Jackson blocked attempts to gut federal agencies. Judge after judge, appointed by presidents of both parties, found the administration's actions legally indefensible. The bombshell moment came when the numbers were tallied. According to Bloomberg's comprehensive analysis, the administration was losing in 128 separate lawsuits as of May 2025. Courts had only allowed contested policies to proceed in 43 cases. The math is devastating. Trump's legal winning streak, the one his supporters constantly brag about, is a complete myth. This move sent shockwaves through Republican leadership. When your own judicial appointees are ruling against you at this rate, claims of a partisan witch hunt collapse entirely. You can't blame liberal judges when Reagan appointees, Bush appointees, and your own first-term nominees are all reaching the same conclusion. The policies themselves are the problem. This isn't the first time a president has faced significant judicial pushback. Think back to Richard Nixon during Watergate when the Supreme Court unanimously ordered him to turn over the White House tapes. Think back to Harry Truman when the court struck down his seizure of steel mills during the Korean War. Even Barack Obama faced judicial defeats on immigration policy. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. But here's the key difference with Trump. The sheer volume and velocity of adverse rulings is unprecedented. According to Just Security's litigation tracker, more than 358 lawsuits were filed against Trump administration actions in 2025 alone. That's more legal challenges in a single year than most presidents face in an entire term. And the losses keep mounting. Professor Stephen Vladeck of Georgetown Law noted that the Justice Department under Trump has asked the Supreme Court to intervene following lower court losses 13 times in just months. For comparison, the Bush and Obama administrations combined made only 8 such requests over 16 years. And let's not forget what happened during his first term. According to the Institute for Policy Integrity, Trump's administration failed nearly 93% of the time when agency actions were challenged in court, typically for violations of the Administrative Procedure Act. The pattern is clear. When courts actually examine Trump's executive actions on the merits, they consistently find them legally deficient. So what allegedly triggered this unprecedented pattern of judicial rejection? According to legal experts who reviewed the challenged orders, the actions violated fundamental constitutional principles in multiple ways. The birthright citizenship order attempted to overturn settled constitutional law dating back to 1868 and the Supreme Court's 1898 decision in United States versus Wong Kim Ark. The federal funding freezes tried to redirect congressionally appropriated money without legal authorization. The attacks on law firms violated First Amendment free speech protections and Sixth Amendment rights to counsel. And the termination of energy grants specifically targeted recipients in states that voted against Trump, a clear violation of the Fifth Amendment's equal protection guarantee. Here's the kicker. In the energy grants case, the defendants actually stipulated, meaning they admitted in court documents, that a primary reason for selecting which grants to terminate was whether the recipient was located in what they called a blue state. Judge Mehta's ruling was direct and unsparing. There's no federal funding exception to the Equal Protection Clause, he wrote. This wasn't a policy debate about energy priorities. It was naked political retaliation dressed up as executive action. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one administration or one set of policies. If a president can ignore court orders 1/3 of the time without consequence, if executive actions can deliberately punish states based on how their citizens voted, if constitutional protections can be brushed aside whenever they conflict with political goals, then the entire system of checks and balances that has sustained American democracy for 250 years is in jeopardy. This puts Republicans in Congress in a nearly impossible position. On one side, they face pressure from a base that remains fiercely loyal to Trump and views any criticism as betrayal. That means defending the president regardless of what courts say, attacking judges as biased activists, and framing the entire judicial system as a deep state conspiracy against conservative governance. On the other side, they must reckon with the reality that judges appointed by their own party, vetted by their own senators, confirmed by their own votes, are finding these executive actions unconstitutional. They have to explain to their constituents why rule of law should bend when it's inconvenient for their president. That's a position that's nearly impossible to defend with intellectual honesty. And here's the tricky part. There's no credible defense. Either the judges are correct and the executive orders violate the Constitution, or hundreds of federal judges appointed by presidents of both parties over several decades are all engaged in a coordinated conspiracy against one man. The latter explanation requires believing something that defies basic logic and everything we know about how the independent judiciary actually functions. Legal and political analysts are calling this a constitutional crisis unfolding in slow motion. Erwin Chemerinsky, dean of Berkeley Law School and one of the nation's foremost constitutional scholars, told news outlets that the Supreme Court faces a fundamental question. Will it check a president who, in the words of his own chief of staff, believes he can do anything he wants? Do me a favor and slam that like button because it genuinely helps this video reach more people. Even conservative legal voices who typically support broad presidential authority have expressed alarm. The independent federal judiciary isn't a bug in the American system. It's a feature designed by the founders specifically to prevent executive tyranny. When judges across the ideological spectrum unite against an administration's actions, it's not evidence of bias. It's evidence that the actions themselves are legally indefensible. So let's break down what this could mean. First, the immediate political impact is significant. With the Supreme Court ruling in Trump versus Casa that federal district courts can no longer issue nationwide injunctions, the administration has gained a tactical advantage. Challengers must now pursue relief state by state, making it harder to block unconstitutional actions quickly. But the underlying legal vulnerabilities remain. The orders are still being found unlawful. The administration is still losing case after case on the merits. Second, it creates a massive problem for judicial legitimacy. Federal judges are facing unprecedented threats. According to NBC News, a dozen judges told reporters they believe the Supreme Court isn't doing enough to defend them against attacks. One judge who ruled against the administration received credible death threats and now fears for their family's safety whenever someone knocks on their door. The U.S. Marshals are investigating threats against dozens of sitting federal judges, many following rulings against Trump. Finally, looking ahead, the implications for 2026 and beyond are profound. Every Republican candidate running for office will face questions about whether they support a president whose policies are being ruled unconstitutional at historic rates. Campaign ads featuring judges, including Republican appointees, explaining why they blocked Trump's orders are already being produced. This is creating a wedge issue that transcends typical partisan divides because the rule of law has traditionally commanded bipartisan respect. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political fallout, this is really about fundamental constitutional principles. The president's role is defined and constrained by the Constitution. Executive power is not limitless. When courts find that actions exceed legal authority, the proper response in a functioning democracy is to comply, not to attack the judges personally or suggest they should be impeached or claim the entire judicial branch is engaged in a coup. This scenario is causing genuine panic within legal circles. Reports indicate that the American Bar Association, federal judges associations, and law school deans have all expressed concern about the trajectory of executive-judicial relations. Some argue the judiciary is simply doing its job. Others worry that persistent attacks on court legitimacy combined with threats against individual judges are undermining the foundation of American constitutional governance in ways that may take decades to repair. Meanwhile, the administration's core supporters remain absolutely convinced that every adverse ruling proves judicial bias rather than legal deficiency. Social media is flooded with attacks on any judge who rules against the president. They're called activists, partisans, deep state operatives. The fact that many are Republican appointees is dismissed or ignored. Things escalated further when Trump himself responded to the mounting judicial losses with characteristic fury. He called for judges who ruled against him to be impeached. He attacked their qualifications, their motives, their patriotism. White House Deputy Chief of Staff Stephen Miller declared the administration was the victim of a judicial coup. Stay with me. What comes next will completely change how you view the situation. Here's what makes it even more damning. The administration's response essentially confirms that they have no legal defense. Instead of addressing the constitutional deficiencies courts have identified, the reaction has been pure political attack. When your defense strategy is to delegitimize everyone who disagrees with you rather than explain why you're right on the law, you've already lost the argument. Chief Justice John Roberts himself issued a rare public statement after Trump called for impeaching a judge. For more than 2 centuries, Roberts wrote, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. When the Chief Justice of the United States has to remind a sitting president of basic constitutional norms, we've entered territory that should concern every American regardless of party affiliation. This goes far beyond 12 judges or even 128 adverse rulings. It's about whether the American system of separated powers, with an independent judiciary that can check executive overreach, will survive intact for the next generation. If there are no consequences for systematically violating court orders, for attacking judges who rule against you, for signing executive orders that your own appointees find unconstitutional, then the entire concept of limited government becomes meaningless. The presidency becomes an office without meaningful legal constraints. And that's not what the founders intended. That's not what generations of Americans fought to preserve. If this blows your mind, hit that like button right now. Here's the situation. More than 200 court orders have blocked this administration's actions. Judges appointed by presidents of both parties, including multiple Trump nominees, have found policies unconstitutional, illegal, and in some cases dangerous. The administration has been accused of defying court orders in 1/3 of cases. And the response from the White House has been to attack the judges rather than fix the legal problems. This is no longer just partisan politics or normal legal disputes. This is about whether constitutional government, as Americans have understood it for 2.5 centuries, will continue to function. When a Reagan-appointed judge with 4 decades of experience says he has never seen anything so blatantly unconstitutional, when dozens of federal judges across the country reach the same conclusion about different policies, when even conservative legal scholars express alarm, we've entered genuinely unprecedented territory. If there are no consequences, it sets a dangerous precedent. Future presidents of any party could treat court orders as optional, constitutional limits as suggestions, and judicial review as an obstacle to be overcome through political pressure rather than legal compliance. Keep a close eye on this story. The Supreme Court is scheduled to hear arguments on multiple Trump administration policies in the coming months, including challenges to the tariff orders and potential limits on executive power to remove federal officials. Legal teams are threatening to investigate the judges rather than address the substance of their rulings, and judges across the country are watching to see whether their work, their safety, and their constitutional role will be defended by the institutions meant to protect judicial independence. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. 12 federal judges ruled against Trump in a single week. More than 200 court orders have blocked administration actions. Judges appointed by Republican and Democratic presidents alike have found constitutional violations. Federal judges are facing death threats for doing their jobs, and the pattern of defiance continues. This isn't just another news cycle that will fade away. This is a constitutional crisis unfolding in real time. What happens next could determine whether the independent judiciary, the last line of defense against executive overreach, retains any meaningful power to check a president who believes he can do anything. The evidence is out there. The rulings have been issued. Now we wait to see if accountability still holds any weight in America. The stakes have never been higher. The evidence has never been more damning. And the constitutional crisis has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.